Good morning. My name is Terry Casey. I'm chairman of the State Personnel Board of Review, and we want to welcome you to this 2002 social media conference. And this happens to be the first conference we've done in a couple years, thanks to COVID. Everybody on board? And I think, I don't know the current number, but a little bit ago we had about 200 people waiting. We're now up to over 400. So this is a great response. And part of it is because social media is such an interesting topic. In recent years when we've done this, this is the one topic that attracts the most interest. And you might kind of wonder, why is social media such a big issue? And that's where I kind of get to the old answer. There's good news and bad news. And the good news today is we've got two super great experts. They're both superstars, and not just in Ohio, but nationally in terms of their knowledge. And clearly on a topic like this that's so complex, it's great to have our two experts here. But now I've got to tell you the bad news. And the bad news is on this topic of social media, there is no one size fits all. In fact, a lot of people said, give us a perfect policy that we can implement for our agency or our employees. And the answer is there is no perfect policy because there is no one answer. So whether you're in a state prison, at a county level, a mayor, an EMS tech, each position, each agency has a little different rules and responsibilities. And you might kind of answer, why is this so complex? Well, uniquely, public employees do have First Amendment rights, and you might be surprised to learn that there's a lot of employees in the private sector. And I know got a good friend who works for a major law firm in New York. That law firm says employees shall not, must not, cannot do any social media. Whereas his wife works for HBO, and their policy corporately is they want everybody doing social media. And there's a lot of companies, news media, et cetera, that encourage people. So in the private sector, there's a lot more flexibility, but public employees do have the rights. And part of the reason why it's so complicated, there's a couple reasons. One, interestingly, at the Ohio General Assembly and the Congress of the United States, they've never written a rule book that says 1, 2, 3, here's what you can do and what you cannot do. So in some ways, this is a little bit of a Wild West show, and you might kind of wonder, why is it so undetermined? And here's the interesting thing. We'll kind of cue up what I call Terry's time machine, and we're going to travel back in time to 1968. And in all honesty, that's before a lot of you on this program were even born. But in 1968, when a stamp was only 6 cents and gasoline was 34 cents. But in 1968, 54 years ago, the U.S. Supreme Court had a case called Pickering versus Board of Education out of the state of Illinois. And in that particular case, decided 8-1, written by Thurgood Marshall and concurred by Chief Justice Earl Warren, a couple names from the past. They wrote this decision that's not the total definitive word on social media, but is a big determining factor that will be mentioned a lot. But basically, you had a school teacher in Illinois fired for criticizing how the schools were spending the money, and he lost in the local courts and the Illinois courts, but the U.S. Supreme Court said, not so fast, and they said he does have rights, and they set up certain rules and parameters, and so that 1968 decision is somewhat the most important. And you're probably sitting there wondering, if that's 1968, how can that case be relevant when clearly since in 1968 there was no such thing as the internet, there were no cable news, no talk radio, no Facebook, no Twitter, there were no smartphones where people would use their camera on their phone to take pictures of things and create postings on various things. So clearly a lot has happened, but that 1968 Supreme Court is still one of the key things involved. Now, the good news today, back to good news, is our two speakers are very good. And part of what we're going to help you do is figure out how to navigate what I call a tangled, twisted road. Make sure you don't go down any dead-end street, that you don't have any crashes and wrecks, because in social media, as they cite some of the cases, there's been a lot of problems. And we want to encourage your questions and comments. And Chris Deach, who's the CERB executive director is monitoring the live chat, and if on there, you can post your questions as succinctly as possible, and if possible, maybe give what county you're from or agency. That helps give a little bit of context, because I know we have a mix of people from counties and municipalities, state government, universities, schools, a lot of people in the 400 or so people tuned in. Now on our 2 stars, you probably have read a little bit of their introductions, but one of the reasons why I think they're so good, example, Jonathan Downs has been practicing a long time in this, and there's lots of attorneys out there in Ohio, but let me hold up a little prop. This is the book. It's a thick one, a big one. This is the 2002 edition, titled Ohio Civil Service and Collective Bargaining, and it says edited by Jonathan Downs. Again, there's lots of attorneys, but not many people have written the book, and Jonathan's obviously been very involved in state and local contract negotiations, dealing with these issues all over the state. And Larry James, interestingly, he survived being a safety director in the city of Columbus, where everybody was mad at him because he had to play judge and jury at times in deciding employee cases. But Larry has also, for the past 20 plus years, been the National General Counsel for the Fraternal Order Police. So Larry's not just been active in and around Ohio, but across the nation, and keeps a pulse on some of the issues, some of the cases that are coming up. So we've got 2 expert speakers. And I might also, one question that sometimes comes up in social media, people will say, why can't you just use common sense to decide what's right and wrong, what employees or employers can do or not? The problem is each person's version of what's common sense is not always agreed upon. So again, we've got 2 great speakers. We encourage your questions, and to mention, this program is going to be archived. So if you or some other people in your agency, governmental unit want to go back and look at it, there'll also be a lot of materials already posted and more to come, but we want this to be interactive. So we'll start in alphabetical order with Jonathan. Why don't you give an overview, and if I've misstated anything, or give your view of where the state of the art is on social media these days. And also you might kind of deal with the question of, hopefully it'll come up, whether your governmental unit has policies, because if you don't have policies, that's difficult. And part of the question is, how did you develop those policies? How did you communicate to the employees on what they can and cannot do? How do you keep people posted on an area that's changing? So Jonathan, I'll let you go first.
Thank you, Terry, and I'm glad to be presenting with Larry. This is quite a privilege for me, and a humbling one at that, because this area of the law is what lawyers dream of talking about, which is the First Amendment and freedom of speech. I will say to you just a couple of fundamental things. The world really didn't change that much with respect to freedom of speech with the advent of the internet and electronics. The written word could get people in trouble if it was on newspaper or as an electronic format. The standards of conduct for on duty and off duty, which we'll talk about later today, is continuous. But I think the key element here for us is that the courts are recognizing, first of all, the standard of conduct, especially for safety forces employees, is the highest of any public employees. And so we're looking at the standards of conduct and what's being applied. Then we get to the fundamental question of, do you leave your freedom of speech as a citizen at the threshold when you cross into work, either in a virtual sense or in a physical sense? And the answer was, as Terry said, in the Pickering case. And then in the outlines of the cases will flow from there. So we have the fundamental recognition by the United States Supreme Court in 1968. I think it was an obvious, to me, it was an obvious decision. I haven't gone back and reread the dissent to see why they disagreed with that, but someday I really probably should do that. But I also want to tell you about today, as far as I'm concerned, the issue that the point of the conversation today is to talk about the speech with respect to the public employees. There's some questions about the policies as they apply to your the jurisdiction's websites. Those are pretty mechanical. What you have as a policy in terms of the speech of the employee, either in a written form, electronic form, or the spoken form, verbalized form, is the standards of conduct question. So I'll break that down a little bit more when we get to that point. But I also want to point out that I am very, very interested in and read again last night Larry's outline and the Q&A that was put together. So I will tell you, as I've told a number of clients in the last couple of weeks, is these outlines are vibrant. These are up to date. This is a continuing develop area of the law. And what you have are a couple of outlines, that give you opposite views as well. Larry's is extremely well written, and it's from the standpoint of arguing what a union or an employee would speak. Mine is more from the employer side. So we've got a good balance here, I think, today for you guys. And I think you're going to hear Larry and I disagree on some of the applications, some of the nuances, and that's what we do. And I think it's important that we indicate what we would do as an advocate in this. There is no bright line test in this situation. There's a lot of context and content issue as well. Going all the way back, the Pickering obviously looked at the content as well as the context, the time and place of where the speech was occurring. So there are multiple moving factors. No one policy can walk through that entirely. Larry's very conveniently Larry's outline goes through what the Columbus social media policy is, and that's about the speech by public employees. I ask you to look at that. There are many, many, many different out there. I think, Terry, you told me there's like 400 different ones that were submitted to the board. And you absolutely can look at these others for templates. You can see the touch points in these. You can find out the policy points that need to be addressed. But I caution everyone, you have to read it first. You have to structure to your organization, and you absolutely must consider the nature of the work of the employee. Different standards for different people because of the nature of the work they perform. Firefighters and police officers are going to be held to the highest standard of conduct. Someone who works in a support position, not so much. So you absolutely must take these in time and context, but also who is speaking. And that's where I get back to the social media policy needs to be read in context and in conjunction with your standards of conduct for the various groups within your organization. Larry, with that, I'm going to conclude with my openings. Other than that, please, and then let's figure out where we want to go from there.
Thank you very much. Good morning, everyone. It's a pleasure to be here. Terry, Jonathan, it's an honor to be on this panel to discuss this particular topic. Couple things. I always tell lawyers, it's one thing to be in litigation to defend a policy. Building the house that withstands a storm is another. So as Jonathan says, you really need to look at what your disciplinary policy is. You definitely need a social media policy. I would say two things. I would have that posted. I would have, whether you're in a union or collective bargaining, I would have it posted and I would have the employees commented on. And there are two aspects. There is the aspect of the various means of communicating as an employee. There's an absolute taboo in most instances. You can't send it from your government email address or your phone or whatever you have that the government has issued. Outside, that may include books, it may include articles, email, Facebook, Twitter, Instagram, TikTok, news releases. Going back to the Pickering case in 68, and I agree it was the right decision, but I think there were a couple things that said, what you'll find from the facts of that case is that the letter was sent, it involved an election relative to a school board taxing issue. And the letter came after the election had taken place. And the other thing the court said, there was nothing untruthful, or at least had been established as untruthful in there. So when you're putting that policy together, and I outlined the Columbus policy to go through because I think it's just been released in the last few months, if I'm correct. But I think it goes through and gives you a good idea what the government entity was trying to achieve The other case that Jonathan and we were talking before is Garcetti, and that came out in 2006. And I remember we were doing a seminar on it, and we thought the sky was falling. And what we came to find, and I remember in 2016, I had our people go through and do a survey of where Garcetti had been followed, where Garcetti had been distinguished. And the court really, a lot of the courts around the country rolled back on that because it was one of those instances in some of these cases, if you're an employee and you're testifying, you're supposed to be truthful. But some employers decided that even if you're testifying and you were truthful and you're testifying against the government agency, that was problematic. And that was just insane. So I think the court had to distinguish some of those items. My outline goes through, like I said, the City of Columbus's social policy. Then we do the First Amendment kind of historical perspective of the First Amendment and the cases. And then I give you a second one that just asks questions and then try to fill in the blanks to give you the answer. But it also depends on what area of the country you're in and what area of the state of Ohio you're in. Obviously, your big union areas are going to be more problematic for employers, employees to go back and forth. And clearly, when you have a union situation where the union takes out a billboard on the city council and or the mayor, or there's a no confidence vote, things of that sort, or do caricatures of them. And quite frankly, I always tell the public officials, get a tougher skin. So with that, I'll open it up.
From
Terry, if I may, I have to laugh.
Go ahead. Go ahead, Jonathan.
The last point, Larry, you may recall this, but a number of years and a couple sheriffs ago in Franklin County, the FOP took out a billboard directly across the street from the sheriff's office, through which his window he could see the billboard.
Yes.
And so Larry's point, I want to emphasize that it's a thick skin issue. And that's when I work with elected officials, for those of you who are serving elected officials, this is an area where they absolutely must be able to withstand it, because the criticism of a public official is the free speech and the open speech that we're talking about. So I had to laugh when you made the comment and the billboard came to mind.
Yep.
Well, maybe that's something the Ohio General Assembly can fix. They can require all public officials to have thick skin. And we might also add in the bill that require everybody to not be stupid in terms of what they do, either public officials or employees. Chris Deach has got the first question. We'll let Chris go ahead.
Yes, Rudy from Perrysburg Fire Division has a question. Are there any cases where social media posts are created by employees under a false name?
Oh, yeah.
Yes.
And then it becomes a matter of proof. But Larry, I think this is a good time to interject. When a public employee speaks as a union official, he is not a public employee. She is not a public employee. And there's some recent cases on that. I think it's, I'm absolutely certain I have one of those cases in my listing of cases, which is one of the cases that you have. So you got to be very, very careful. If they are speaking from the union podium, behind the union podium on the platform, they are speaking as a union official. They are wearing a different hat. Larry, what do you think?
I agree with that 100%. I think if you're not and you're speaking as an employee under some name trying to cloak it, they're going to find out. So that's not going to be the cover that shields you. And the normal standard of review is going to happen. So whether you're writing a book, whether you're publishing a letter to the editor, whatever you're doing, it's going to apply to you. The exception is the union piece.
The other thing, Larry, that I have seen a couple of cases on, and I understand some unions have already advised on this. If you click like on somebody else's Facebook posting, then you've adopted that as your speech.
Correct.
So liking something is adopting it, and also a matter of potential political speech. So for which people who are out there, that's my caution to union leaders, is to make sure that your members understand that if they like something that's hate speech or that's derogatory or would cross over the line and for which they could be held accountable, they must know that. In the same vein, in a case out of the district court in Norfolk, Virginia, a like of a Facebook posting of a candidate was found to be the same as putting a yard sign in your yard, and that was protected speech. So you have to be careful of what you like, or you can be like me and not have a Facebook.
Or there's the other situation. What do you do about your spouse? If your spouse is writing the letter, or someone in your household is writing the letter, we've seen a number of those cases, following up on Jonathan's point, where the sheriff was running for re-election, and one of the members put a yard sign for the opponent in their yard. He said it was the wife. That gets a little bit dicey, Jonathan. I don't know if you've dealt with that up close, but the idea of your spouse or someone writing that letter, you're going to go through some hoops because the employer, particularly sheriffs, where we see this a lot, are going to come after you and try to terminate you. And the question is, do you have a right to that job versus the sheriff just cleaning house?
Well, there was a
We've
case,
got a-
appeals court on
Go
the other
ahead,
side,
Jonathan.
on the East Coast, that held that a man getting a yard sign, an employee getting a yard sign for his mother was political speech,
Right.
and therefore protected. I always, my advice always is make sure that the yard sign is in the wife's side of the yard. No, yard signs are protected. And I have not seen in Ohio any cases on that, although we still see some from other states where they don't have collective bargaining or civil service. So Larry, it continues to be an issue. I have not seen it as an issue here. And I think, Terry, this might be a point to interject that speech by an exempt employee, non-civil service, non-collective bargaining, the elected official can hold them accountable, kind of like a safety director. If he would have said something that the mayor didn't like, well, then the safety director is done. Does he still have his freedom of speech to express his opinion and losing his job? Most of those cases I've seen, Larry, I don't know if you've seen it opposite, but if a unclassified exempt employee is terminated and it's alleged that there's a connection to his speech, that a First Amendment case usually does not move forward. I haven't seen one where an unclassified employee has made a case in Ohio. Have you?
And to further that point, and you see this again with sheriffs, because sheriffs come in and they want their top folks to be loyal to them. And if you've supported the opposition, you're going to be fired, and First Amendment arguments are not going to help you.
Let me jump in a second. The good news, we're up to 581 people on this call. So obviously it's good to have superstars. It attracts people, and we've got good information. And I think Chris has got another question. Chris?
Yes, a legal intern for Sorta Metro in Cincinnati says, so liking something on Facebook is considered expressive conduct?
Yes.
Absolutely.
And the courts have said so.
Yeah.
And obviously I might mention Congress is now talking, you may be seeing commercials of people wanting Congress either to regulate social media or not, but that's really not going to deal with employees. It's more what can the companies do. So clearly social media is something where is the richest guy in the world is supposedly going to buy Twitter, but maybe he's not, and what's it worth, and false accounts. Again, this is a hot topic that there's always a new story each day. So anything else additional on likes? So your view pretty clearly on both sides is if you're liking somebody's post, you're in essence adopting it, and
Correct.
It's becoming yours.
Correct.
So, Larry, I think it would be helpful for us to spend a little bit of time talking about what is a matter of public concern.
Right.
You've already introduced it with Pickering. Anything more that you want to say about what is the test of what is a matter of public concern?
No, I was thinking I was just going to go through the 4 key questions that
Okay.
kind of outlines, and just to kind of not to be too legally, but the court must first determine whether the employee speaks to his official duties. If the employee speaks pursuant to his official duties, then there's no constitutional protection for speech, and we can get into that. If an employee does not speak pursuant to his or her official duties, but instead speaks as a citizen, the court must then determine whether the subject of the speech is a matter of public concern. And that matter of public concern, the courts are all over the place on that. If the speech is not a matter of public concern, then the speech is unprotected and the inquiry ends. If the employee speaks as a citizen on a matter of public concern, then the court must determine whether the employee's interest in commenting on the issue outweighs the interest of the employer, and that is the camaraderie, the safe working environment. In the police cases, if you see hate speech, stuff like that, does it hurt the department, things of that sort. And lastly, assuming the employee's interest outweighs that of the employer, the employee must show that their speech was a substantial factor or a motivating factor in the adverse employment decision. That is, after the employee posted or made that public speech, then there was a retaliation. Jonathan, you want to weigh in beyond that?
Well, and I kind of want to split the path here first. So speaking as a government employee, let's set that to the side for just a minute, because I think there's two veins on this. The first one being what Larry walked through, and it's those posts which are of hate speech and derogatory negative about individuals. So I put them in two categories: criticism of the elected office holder and public speech. And that's the analysis that the Sixth Circuit went through in the Marquardt decision, which is listed in my in the list of cases, where a white captain EMS city of Cleveland posted something after the Tamir Rice shooting saying, "I'm glad he is dead." Well, he was immediately fired and went up to the courts there, and the court said, that's not protected speech. But then the appeals court of a conservative Sixth Circuit appeals court said, no, it is a matter of public concern, because the issue involved was national news. It was an issue of major concern for folks in Cleveland, and sent it back to the court, district court in Cleveland. And the district court then indicated, it went to the next part of the test, which is it disruptive to the operations and or negatively impact the reputation of the city of Columbus EMS. And then on the second part of the test, as Larry identified, the court dismissed the claim by former officer Marquardt. It's now back up at the Sixth Circuit. So we will have very soon a decision on that. Our office, the Cleveland office, is handling that case, so we're in the weeds on that one as well.
Jonathan, you want to talk about what the trial court did the second time around that sent it back to the Sixth Circuit?
I think they examined more about the potential disruption to the workplace. They talked about what Larry said earlier, which was the standards of conduct of someone in a position of trust. Had that been a statement made by someone who worked inside of a light plant, a water plant, a wastewater plant, it may not have garnered that attention. But the work rules there were applied, the standards of conduct. And that's where I get back to the fundamental standards of conduct in your various departments. So fire department, police department should be very, very similar with a few differences. And Larry, that's my takeaway on it. Did you see anything else from the district court's rereading of that?
No, and it's always about which judges you pull on these cases, and obviously that's the judge on this time, they had the right judge, and I don't know whether the panel will be the same when it goes back, but I don't expect them to reverse it a second time.
My only regret on the case was the judge didn't go to the second part of the test and say, I don't think it's a matter of public concern, but in the event that it's not, or we wouldn't be spending more time in the Court of Appeals. Not that we don't like to spend time in the Court of Appeals. That's there's only one court higher than that.
Let me jump in for a second. You're on a good topic, but Chris has got a few more questions and we can come back this morning. So did you want to finish one thing, Jonathan?
I want to finish the one thing that's very important, going back to what Larry said earlier. The Marquardt decision on the Sixth Circuit appeals, I went through the policy of the city of Cleveland and said it may be overbroad. So we have here in Ohio, and I think the city of Columbus policy incorporates some of the cautions from the Sixth Circuit Court of Appeals, the Marquardt decision, which was, I think, like 20 months ago, almost 2 years ago. So the Sixth Circuit is already examining the nuances of the policies in that decision, and we'll have more guidance from them very soon on that. So I'm sorry, Larry and Terry, but
No, go ahead.
that was important to see that they actually spent time on that, because that was the one point of attack by the plaintiffs.
And we can come back later to a little more on overbroad and vague, because that's always one of the questions. Chris, do you want to give us an update?
Yeah,
Questions?
there's several questions that have popped up in the chat. One of them is from Kathleen, who's with the city, and she asks, if a council member violates the city's social media policy, are they considered an employee or are they exempt as a public official?
Larry, that one's yours.
Well, you know, what we've seen in the past, and Terry and I have seen this in our lives, is that usually that's where you might have a citizen's complaint on a mandamus action to hold that public official accountable. Because I would say more often than not, they're going to be exempt. And not exempt just legally as a policy decision. Because as a public official in the public arena, they're going to get to comment on a lot of things. And where we see this most often, and that just drives law enforcement community crazy, is the comments on shooting. Whether you're a mayor or city council, they act as judge and jury automatically, and there are no consequences.
Larry, I will slightly disagree with that last statement, because one of your colleagues in Cincinnati used the comments by the elected officials in the arbitration decision dismissing someone who wasn't involved in a use of force case. So I caution the elected officials that I represent, be careful what you say, because you will have to eat those words later on. So is there a consequence to the elected official? No. For those of you who are in administrative and management positions, and especially in law enforcement and fire service, EMS service now, you have to be careful what's said, because if you take action in a disciplinary sense on an employee who made a comment, that language will be used in your arbitration hearing as an argument of being prejudged.
In particular, we saw that in Atlanta cases. You remember the taser cases that the mayor fired him on the spot, and then everybody in their world came out and called him everything but a human being. The arbitration used that as a reason to reverse and reinstate the officers. So there are no personal consequences for the public officials. Right. There are government consequences for their actions.
And I think it's, and I see the policies of putting someone immediately on administrative leave while the comments are being made, and that gets back to whether or not your elected officials say something, and what they say, they're going to be pressed to say it. And the media is going to have the mic in their face immediately, and 62 cameras. But so my follow up on that is the removal action will be the next election.
Good. I think Chris has got a couple or additional question. Go ahead, Chris.
There are several, but one of them is from Jennifer from a county health department. And she asked if an employee is with the health department, likes something on Facebook as a private citizen on their own Facebook page, but their Facebook page indicates that he or she works at the health department, can this be considered a health department perspective, or is it okay since the employee is, quote, liking as a private citizen from their own Facebook page?
The answer is she's going to be held accountable. From that standpoint. So whether it's in the public arena or in her private Facebook or whatever her private communication is, if it's something that is derogatory or violates the policy, because the policy should speak of both off the clock behavior and comments and actions and on the clock. So it's still going to be judged by that same parameter. She doesn't, the employee will not get a pass.
Larry, I actually had such a case with the health department by a nurse having a picture of herself eating the famous cookies from Colorado, spiced with the usual Colorado spices, and was a public health nurse, and that was posted on her Facebook, and she was held accountable and and disciplined for that. So we get back to the singular initial point on this was you have to show a connection. Public health nurse, police officer, EMS captain, connection to the reputation of the organization.
The city of Philadelphia, and I don't know if I'm jumping ahead, but if you followed the news, maybe about a year and a half ago, the city of Philadelphia hired an investigator to go and look at all the personal posts of all the police officers. And as a result of that investigation, there were 23 officers that were terminated for their private posts.
That didn't come out well for the city, if I remember correctly.
Yes, yes.
So ultimately, what happened, Jonathan? Did the employees get their jobs back, or were they out?
They got put back to work, and kudos to the FOP. I co-present with the FOP attorney in Philadelphia at another seminar. So that's one of those where are you looking for something? Are you turning over every rock and looking? It just from a standpoint of a major representative, that didn't pass my smell test.
But you're going to have those consequences, and where we see arbitrators are going to view these employment cases more often than not very different than a court of law. I don't know if you want to comment on that, Jonathan.
I absolutely. In fact, I think I included it. A recent arbitration decision. This is one I presented at the Police Chiefs Association, that other organization, Larry. The key is to me has been more of these cases about freedom of speech that result in discipline are going into arbitration. First of all, because it's quicker. Second, because that's the union's role and responsibility. And I think Larry's point is what I would agree with, is that arbitrators are more receptive to an employee's ability to speak and less likely to enforce a standard of conduct issue on a freedom of speech issue. So they're more lenient than the courts. They're not bound by Garcetti. They're not bound by Pickering. They look at the question of just cause, and they develop what they believe is the standard for just cause, kind of like the way the State Personnel Board of Review does when they look at what is the standard of conduct under 124.34. You know, we find, at least I have, Larry, in the cases that I've read, we see that more often. So that's what when I prepare a case for discipline, working with a client in advance, I always keep both eyes open. One eye is open for the freedom of speech issue, and the other eye is open for what would an arbitrator say. I should have a
Any added reaction, Larry, before we move to more questions?
Yes, I just want to go down, because Jonathan and I were talking earlier about what constitute matters of public concern. Yes. And so generally, just kind of an outline, you may comment on allocations of agencies, patrol force deployment, and an officer safety, things of that sort you may comment on the need for the effect of reorganization in a department, public opposition to use of volunteers in property room, criticism of capabilities of bomb squads to respond to emergency safety, statements critical of DNA review and things of that sort. So when you deal with public concern, you're going to get to a lot of different areas, and how it's structured will also matter a lot.
Good.
So
Chris has got some additional questions, and
let me
right
follow
now,
up on that.
almost 600 people. Go ahead, Jonathan, and then we'll go
There's
to
a
Chris.
balance in there in terms of what's public concern, and then the Garcetti standard on top of that, because the case that it's in the materials is the Anderson versus City of Jellicoe out of Tennessee, and that's where two of the officers went to City Council at their invitation to talk about the organization, and then were later terminated. But the Sixth Circuit Court of Appeals, and this is just last month, said it's not protected because it's in the scope of their duties. So that's Garcetti applied as well. So we have fresh decisions on that point here as well. But it's, again, we get back to the Marquardt decision. Sixth Circuit said the comments made about Tamir Rice was a matter of public concern. It's not the organizational issue. It's one of the things I think that if you follow Larry's examples, they're all about the organization.
Correct.
And so you've got the case out of Wapakoneta about a fire truck. You got the case out of Bay Village about a swiftwater rescue boat. Both of those came out of fire departments. So we have a treasure trove of cases in Ohio. We don't need to look too far for what is a matter of public concern, and then the Garcetti rule as well.
Good.
I'm sorry,
Chris,
go ahead.
what other questions? So we haven't, again, we're right near 600 people attending and participating. So we're great to have this kind of involvement. And if we'd done this in person, we might only be able to get 150 or so in a room. So having 600 plus is great. So Chris?
Okay, I'm going to do two questions. They're very succinctly different, so you'll be able to separate them out. One is from a school district person that asks if an employee criticizes the job they do, the leadership or the school, do they have a right to delete the post if the post is on the district's page? And does this type of speech make a difference if it's posted on the district's social media or their personal page?
Yeah.
And then do you want the second question?
Yeah, go ahead and put the second one
Okay,
out.
and the second one is from Lori, who's with a city council. She wants to know, what is your opinion of a city council person live streaming council meetings? Isn't there a concern about public records with the city not having records on comments made during the live stream recording of the meeting?
Let's take the first one. It's easy. The first one, you're dead at hello. You don't get to delete. Delete doesn't eliminate. So sorry about that, but the answer is unequivocally no.
I will kick in on that as well. How did the person get on the website? I mean, so you have your internal websites, your internal social media issues, Facebook websites, whatever. Cities, schools, counties, you control that. If your policy doesn't have something in there about who can post and what posts can be taken down, then you got a problem. You need to go back and fix it immediately. As far as public records is concerned, that's been addressed, and I think Larry provided the guidelines for electronic records management. It's one of the documents that y'all have, and so I would direct you to that point. But the website or social media that's maintained by the employer or the public entity, that's your responsibility. If you allow public posts, okay, then you need a policy about what can be taken down. And there's plenty of case law on that, and the guidelines will give you the checks on that. And so even though you say, well, we won't let anybody post from outside, think again, because police departments use the website for tips to be posted. So there's a reason to keep them open. I mean, there's one lawyer in town here who says keep it open, use it, but you have to monitor it. So the first one is, yeah, you can take it off, you can shut it down if it violates your policy, but you have to have a policy there. The second then on the school district person is if it's on a personal page, then you hit the standards of content, time, place, standards of conduct, and so forth. So it depends on what. I'm going to get back to the first words that Larry has in his outline. It depends.
Yes. And I think on the second one, I don't understand. Is the person asking if they're live streaming the city council meeting, can they, does that become a part of the public record? I think if for some reason the public recording fails in any way, shape, form, And we've seen this in police actions where people are using their phones to record actions. You're going to get subpoenaed. If there's a deficiency in the record and someone's aware that you have recorded, you're going to become a part of at least an investigation.
Lori, I'm going to err on what the Supreme Court says, which is transparency in government. To me, my analogy is if this council person uses his text or private email to conduct city business, those texts and emails are a public record. Period.
Absolutely. Absolutely.
Larry, I don't see any difference between live streaming a video and if it's being recorded. I mean, if it's just live stream, it's not recorded, then I don't know. That's a technology issue you'll have to ask Justin about. I don't see a difference between live streaming and emails.
Exactly. Yep.
Then, Lori, it comes to the point of what does your public records policy say? What does your records retention? What's your RC2 schedule say?
Yeah. And and I think the idea is by state law, and we sent that out as a part of that to go through whatever your communications are as a government entity, they are official records, and there should be a record retention policy, and it just goes along with your electronic record retention policy.
Chris has got a couple more questions, so I'll turn it over to Chris.
There's two, and it's out of the Akron area. What if someone else posts something and tags you in it? Are you still held accountable? And additionally, what about posts prior to public service?
Well, if it's prior to public service, then the public employer didn't do a very good job of a background check. The tagline, I'm going to have to defer on that. To me, if I'm tagged into something and I leave it there, then I'm responsible for now. It's now on my website, so I think it's I think it's the same as mowing your grass where you have a law. You can't let these things gather. To me, that employee would have a responsibility to take it down or to block it, but that's one where that would be handled by a conversation as opposed to discipline. That would be my approach to it, is tell the employee to block that, take it down, and beyond that, you'll have to ask someone from the technical world how to do that.
The employee employment problem, and I had this happen as safety director. There was a officer that I had appointed, happened to be a white female. And 15 years later, I was long gone as safety director. Some of her publications became public because she had made some statements 15 years later, and as a police officer, that showed a racial hatred. So it has consequences because it will hurt the government entity that you did not do a very good background check and you are not monitoring this individual who occasionally these things would surface. So whatever you do in your adult life at the very least will live with you forever.
And part of things living forever is the fact that people can do screenshots. So you might post something stupid one night, but somebody captures it and then they spread it out. So these things, good or bad, you think they're gone, but they aren't always gone. So turn back to Chris. We've got another question or two.
The question is that this individual, their particular place of employment has a policy on Facebook page that states that they will hide offensive speech and they have controls on certain words that folks cannot type into a post. Is that enough?
Yeah, I'd like to see a little more granular, some descriptions of that, but that's minimal. I'd like to see a little more. But
yeah, I would say from a risk standpoint, if you're a government entity, you probably want to control what posts. If you're a union, you want to control what posts, because you're going to get some crazies out there that are going to probably do some crazy things. I just think that's a dangerous place for the government to be when you allow each and every employee, unless it's really refined and controlled. But that makes me a little bit leery. I wouldn't want to be the author of that policy.
And I think, Larry, that in some of the policies that go into the ownership by the entity that the CERB has collected, I think there's some sample language in there. I would encourage you to read all 462 pages and sort something out. You can do a word search.
Yeah.
Even I know how to do that.
Yeah.
So the one thing you're talking about, though, there is regulating the content. And that's the ongoing discussion on a national level currently. Can you regulate the content? And if there was a case, the Knight versus Trump, where he was regulating the content of his Twitter posts. And at the time, there was also companion cases that were filed against several of the congresswomen at the time. I'm going back about 6 years now, 7 years. And the courts clearly held that you can regulate the content, but you have to have specifics. You just can't take it down because you don't like it.
And Jonathan, the other thing we've seen is, I think, and this was in Trump's and maybe a couple other public officials, that they were blocking individuals that the court said you can't do that.
Right. And it was interesting because it covered every political party of those cases. Right. It was kind of like this thing: we block everybody we don't want to hear from, and the courts were. A couple of the cases were settled before there was a decision, so it was across the board. It was what people did in way back in 2016. A couple of quick examples. I just went back to my outline, Terry. Examples of conduct that are not protected because of the scope of duties, Garcetti. And so we have cases out of Sixth Circuit, 2000, going all the way back to 2007. Comments by a park ranger to a third-party consultant about discipline, morale, and performance problems in the department was not protected speech because it's within the scope of duties. And if you want to look at more of those cases, they're on page 5 of the outline that I submitted. And Larry's, curiously enough, are also on page 5 of his outline. So give you a cross reference to your notes. You can look them up later. But there's a series of cases, and one of the things I want to throw out here is Terry pushed both of us to give some content to this. Unfortunately, I think we both have outlines. These are ongoing outlines that both of us have been updating for years. Yeah. So a lot of them are intended to give you case examples. The standards by the Supreme Court are there, but case examples both are replete with a number of examples for you.
Yeah.
Good. Let me check with Chris. Do we have any questions upcoming?
We have a number of questions, but they have been generally responded to, so I'm holding on those.
Oh, okay.
Well,
Let me ask both. Go ahead, Larry.
One of the cases I referenced, it was a case decided on March 28, 2022. It was out of the city of East Chicago. And we see this in a lot of small townships and small government entities where the administration changes. And in this system, we had firefighters who had opposed one of the candidate, and that candidate that they had opposed, and they had opposed this candidate vigorously. I mean, everything you could imagine, they did. And the question was the shifts, the 24, 48-hour shift, on duty for 24 hours and then off for 48. And what the incoming administration did, they were very punitive. And now deciding work hours for the firefighters. They sued and they petitioned the council. And the court agreed with the union in this instance that they were retaliated against for their First Amendment rights. So where we see those small jurisdictions where everyone knows everyone and you want to retaliate, be punitive, and I think courts will look favorably on that action. Jonathan, I don't know what you think. I still think this is a rare case. Because it's hard And we were talking about earlier on the sheriff's side, and I think the incoming administration just wasn't that smart in how they did what they did. So I'll leave it at that. Jonathan, your thoughts?
I'm 100% behind you on this one. The East Chicago case is the fact pattern. When I read the case, and then your update as well, I love that. It's to me it's bizarre. But these things continue to happen. Here you have the firefighters through their union. You have an extraordinarily strong reaction by the candidate-elect. So whoever's coming into office, and I'm council members, township trustees, county commissioners, county prosecutors, whomever, you've got to look at this issue about retaliation. And I think that's the word, Larry, that we haven't spoken of yet,
right,
which is the retaliation aspect of
right.
this. And under discrimination laws, it's easier to make a case factually and under the law for retaliation. Same is true here. So those of you who are familiar with discrimination cases, even an unfounded allegation of race, age, sex, national origin discrimination, if there's a retaliation based on having filed something. Same thing here. So the standard retaliation, and one other tweak here, if the speech is whistleblower,
Yep.
then that is also protected speech under the First Amendment and about 300 laws under the EPA if you're dealing with 300 laws. And one little buried section in the Ohio Revised Code Civil Service Law is 124.341, and that is the retaliation provision in the state statute. And Terry, I think you had a couple of words to say about how the board views that, and give folks a link over to the freedom of speech issue.
Right. One of the things the State Personnel Board of Review does deal with are whistleblower cases. Interestingly, under the law on whistleblower, the burden's on the employee to prove that what actually happened. Normally, when county or state or university employees are dismissed, the burden's on the employer to prove that what they did is correct and justified. But there are laws in Ohio on whistleblower, and it does get complicated, and it does intersperse with the whole business of social media and people's comments. And again, I think today, because there's so many channels where people can express themselves, they feel more freedom or flexibility to say whatever they think or whatever comes to their mind. Obviously, people's filters, some people's filters are not as good. They feel whatever they think, if they say it, it must be right. So that's part of the challenge. And let me mention, before I go to a question from Chris, somebody asked, how do we access these materials? And if you go to the SPBR website, you'll be able to see, and we'll be upgrading and make it easier to find.
Under the news section.
It's under news. So look under news on the SPBR website, because again, Jonathan and Larry have given us excellent background materials that are very helpful, and they're also free. Am I right? So, and I might also mention that we at SPBR don't give out legal advice. You need to talk to your appropriate attorneys on that, but hopefully this information gives you, again, a guidance to make sure you don't go down a dead end road or you end up in a car wreck. Let me turn it over to Chris as a question or two.
One is that most people have individual social media accounts set to private. The question is there anything preventing employers from asking for social media handles or passwords so a background check can be done?
Absolutely. That, if you're not going to, let's put it this way, you don't have to turn it over, but you're not going to get the job. Yeah, I mean, when I'm talking to the private employers and to some degree public, I mean, you ask for your password and all your social medias. My wife is on a number of corporate boards, and I can tell you unequivocally, I know what they do in that area. I don't know what they're doing in the public arena on this area, but I know in public safety, they're asking for all that background information. The non-public safety individuals, I don't have any experience with.
That's where the line's drawn mostly, Larry. Again, I'm advising clients, show me a nexus before you ask for that. And there's a couple of references in Larry's outline to the NLRB with the National Labor Relations Act, which obviously doesn't apply to public employers in Ohio. But I think it's important to see what the NLRB is doing. It's doing its usual political flip-flop. I expect that, asking for those sorts of things, the backgrounds and the social media, if this board gets a hold of it, that's going to probably be found to be a chilling effect and therefore illegal. But I don't see that so much in the public sector because the difference is it's taxpayers' dollars. If you're asking for someone, and so Larry's example of 15 years earlier, a white female police officer made some racist posts. Is that something that you should be able to discover as a law enforcement officer, as background check? I think you need to look into it and so forth, but that gets to be a policy question internally.
Yeah.
And
go ahead, John.
Just as a follow-up, the one thing is, if they work for you and they had it set to private, ain't no such thing as private.
Yep. The one thing we had talked about earlier as we prepared for this, the one glaring exception to all of this has been the COVID area where employees, public, have been all over the place on whether they're going to get the COVID. We've seen law enforcement who just flat out refuse, and they've been threatened. I don't know if that's going to change or not, and people publicly commenting on that. Jonathan, you have any thoughts? Terry?
My thought, Larry, was very simple. It's a matter of public concern, so I think it crosses the first threshold. If they're being critical that's the internal issue, for instance, if it's someone from a health department being critical
Right.
of that person's employment. So I go back to the Garcetti test, but basically speaking, anybody else, police officers, they can be critical of the vaccination requirement. That's a matter of public concern. I don't see where I would be able to make a case that it's not.
Right.
And Larry, I don't know of any cases in Ohio. Now, Will Atchison out of Oregon keeps a track of those things going.
Right.
He's a couple hundred of those cases on his list, but I don't really see much of that in Ohio. I think a lot of that had to do with lots of communication, lots of educators going along and respecting that people can have different opinions about vaccinations and whether or not you get COVID.
And I think the bottom line, though, irrespective of whether their commentary, I think 96% of the cases that have been litigated where the employer has required the vaccination and there's been a refusal, they are terminated. And Chicago is the is the poster child of all that, although the mayor has backed off because she's in a tough election and law enforcement are doing their thing. So, but I would say that that's probably the difference, that if, you can comment all you want, but if you don't show up, you don't get the vaccination, that's the requirement, you're terminated.
Let me check back with Chris. Any additional questions?
Yes, there's one that is dealing with social media and records retention. And the question is, are public comments on a social media post required to be retained? And for instance, if someone comments and deletes later, should we have a record of that?
I
Chris,
think,
are they talking about somebody who's on a public social media site, or is this on a private one?
They don't define that.
Okay, well,
We'll try to find out.
I assume they're probably talking about if, say, the governmental unit has a social media website.
That's what I'm
People put
assuming.
things on,
Mhm.
can people take them off, and does that disappear or not?
Correct. I think that's what they're asking. And
They
if
don't-
they do delete something, is it actually hidden?
it doesn't disappear.
Okay.
It will be found. And I'll tell you, this is a little bit different. The case out of Philadelphia when they were having the riots, and Philadelphia just settled a case with a woman for $2 million. We in the FOP had posted a photograph of a child and that woman, photographed an officer with a little 6-year-old child holding it, and the tagline was, "We're here to help." We've now been, the city of Philadelphia was sued, we were sued, all our posts were asked for, and we had to go back and retrieve them. So I would say anytime there's any controversy, those posts, whenever they were posted, is fair game and will be had.
Records retention 101. You absolutely must have something in your records retention about when you can delete those. So the basic standard, when they're no longer of administrative value, you decide when that is. But here comes the computer side of this issue. Computer geeks don't like to delete anything from computers because I got all the storage space. Well, I got this thing called the cloud, wherever that thing is. It's over on the east side of New Albany, by the way. So you got to take it down and you got to get rid of it, and it has to be gone or it's still a public record. But you absolutely must have something in your records retention schedule, which is an RC2, and go through the process. And whoever's monitoring that, if it's gone because a person took it down, my question is how the devil were they able to do that? So there's a glitch in your software there somewhere in your program. But yes, it's still a public record. Yes, it's still subject to disclosure, and yes, it will be. You must disclose it unless you have a records retention policy in place.
Let me jump in and ask a question on policies. There's been different things that I might mention for those of you. The Sixth Circuit that's been mentioned several times, a lot of people forget. It's based in Cincinnati, the Sixth Circuit Court of Appeals, and for most cases, it covers a 4-state area: Tennessee, Kentucky, Ohio, and Michigan, a good chunk of America. But for an awful lot of cases out of Ohio, that is what amounts to the ultimate Supreme Court, because sure, there are some cases, maybe 80 or 90, that get to the U.S. Supreme Court, but most cases are finally adjudicated out of the Sixth Circuit. So there's been several mention of cases there, and that's very important for background. But could either of you kind of speak to where's the line between what's vague and overbroad versus specific enough? And of course, it's hard to detail every single hypothetical question that might come up, but how do you balance out what's vague and overbroad and confusing versus specific enough and clear enough? And I might mention, I had one state government official tell me that, well, our policy, what we really want is harmony among all of our employees. And I said, how do you define harmony and how do you enforce it and where do you draw the line? So Jonathan and Larry, give us a little more background on where the lines are of demarcation on broad and vague versus specific and understandable.
Well, there's a case that Larry has in his materials, right, at page 9, the Moser versus Las Vegas Metro.
Yeah.
Where I disagree with the Ninth Circuit decision on this one, because it was a hyperbolic political statement lamenting police officers being struck down in the line of duty.
Right.
The comment in there was it was a public concern, and I think the policy in that situation I thought was not overly broad, and the court looked at the question of intent. And all I need to say is Ninth Circuit is part of it. But I think that's part of what Larry's getting at is the needle is moving on how and where Garcetti applies on the vagueness of the policy or the specificity of the policy. So it's, I always use the word common sense, and I say sometimes I'd like to see policies actually include those two words. And I've advocated for that many times and have written it into rules on behalf of clients. And I think the language, Terry, turns on whether or not the court interprets the words that are used to say what the standard is, if that would have an effect of someone not wanting to speak or chilling their speech. And in the eyes of the beholder, you get to you go over to our quad, which maybe follows a little bit of what Moser said in terms of the breadth of the city of Cleveland policy. And that was written by Judge Sutton, who then turns around, and Sutton authored the case out of the Anderson versus Jellicoe case, which was clearly a Garcetti application. So I can't tell you that there are magic words there. I would point to the language that the city of Columbus has used, and there's several others in there that I would look to as well. But I'd also caution you, the city of Columbus is a very extensive policy covering a lot of different things, covering how many thousands of employees now in the city of Columbus. So be careful how far you go. For those of you who use Lexapol, especially in law enforcement and safety forces, I caution you on that one. You need to get a little more granular on application in Ohio, because Lexapol writes those policies on a national level. Larry, I don't know what your experience is in reading the Lexapol policies. Basically they have some good standard policies, but on this one I'm a little more cautious. Larry?
Yeah, I would say that, you're talking about the standard due process and notice, the adequacy. If you read the policy, does it instruct one to say this is a violation? You want to say a bright line, but I don't think the courts go to a bright line as much as, were you on notice that this clearly was a violation? So if you have past practice, and this is what we get into the union all the time, and you have looked the other way because you like this employee, or the content was much more acceptable, and whether it's in application and enforcement, but it's about the clarity of the notice.
Chris
And
has
that's-
got another question, and by the way, I
Sure.
might mention, we've got about another 15 to 25 minutes left, and don't be shy. If you've got some questions, please let us know. But Chris, go ahead.
Yes,
Terry-
a public library
Terry-
indicates they advocate for intellectual freedom, and they ask if employees post their opinions on things like the BLM movement, Roe v. Wade, and other divisive issues, would that be protected speech?
Yeah. Garcetti does not apply there unless they're damning the library itself. But I think, whatever side of the political issue, and we've got a hot potato coming. It's going to get hot this summer. There's going to be a lot of speech again on both sides of the issue, and some in the middle. But if they advocate on the outside, but on the flip side of it is, if that's advocated from a position of someone who works for the Department of Health, I think you might have to look at that. It's kind of like the medical marijuana issue and someone eating cookies in Colorado. Again, it gets back to the Marquardt decision. I would say, even if it's inflammatory, which those comments, in my opinion, clearly were, it's a matter of public concern. And a conservative judge, Sutton, wrote that. And he really focused in on the First Amendment.
Yeah, I think the thing you've got to understand is when we look, so when I'm giving talks to the National FOP and the members, I frame the question like this on a lot of these hot button issues, and for law enforcement is, a mayor or president of city council, whether they're right or wrong, they decide on what's going to be the discipline on statements made by individuals. Am I going to allow my city to burn, or am I going to have an arbitrator or a judge put this individual officer back to work? So in your large urban areas, depending on how hot the season is, no matter what your written commentary is, the political winds are going to go against the employee.
Terry,
Chris,
back,
any
oh,
addition-
Go ahead.
Go ahead, Jonathan.
one of the things that I would suggest to you, for those of you who have a policy, you review it, you don't think you need to make any changes to it, that's fine, that's great. Pick 3 or 4 or 5 people from different sectors of your organization to read it and see if they understand it, because that will be the litmus test that Larry's talking about. Do you understand about the conduct and the consequences for the conduct? And that's, to me, that's fundamental in any policies, any manuals. You have someone who has to live under it, read it, and pick someone who has common sense. Of course,
We talked about that. So, from a union standpoint, you want a collective bargaining agreement will speak to this, and it's negotiated. In the non-collective bargaining jurisdictions, I think that's absolutely the way to go. Post it, have a comment period, and I think you're going to be in a much better position.
And quite honestly, Larry, I like my clients who have unions police, fire, whichever, to have a labor management meeting and to present the social media policy and say, here it is. This is here to protect all of us. And you can use whatever cases you want to example as to how it affects or demeans the officers. Because I can give you plenty of cases where comments made by a police officer to members of the public made it more difficult for other police officers to do their job. And that's the ultimate issue.
Chris has got another question.
Yeah, County Health Department is asking if you think that investing in social media archiving software, something like Archive Social, is a good idea.
Okay.
Depends on your budget. Yeah, I mean, I think all of this stuff helps. I mean, best practices when you're talking about that, absolutely. Can you maintain it? Can, you know, when we look at the capacity to hold social media, do you have that within your budget and in your different departments? One of the things I wanted to talk about also, and Jonathan knows about this case, Novak, just, you know, when you're talking about posting, so we had this citizen, this was a private citizen who decided he was going to do a spoof on the Parma Police Department and created a separate Facebook page to talk about police-related matters. The police became aware of it. They investigated it. They criminally charged him for falsification and, you know, and things of that sort. He was ultimately exonerated. The case went up to the Sixth Circuit, and they dismissed the case on the grounds of qualified immunity. But Jonathan, you'll remember the last few paragraphs. They were not happy. They said the court questions whether Facebook page was worth an entire criminal prosecution and countless appeals. However, because of the law compels it, the dismissal is affirmed. They were not happy with that, but that just goes to show you, you know, depending on what you're doing, if you want to hop on someone's or do a parallel comedy, whatever you want to do, it too has consequences. I don't know what the Sixth Circuit wanted to happen in that, Jonathan. Did you get a clarity of it?
I think that they in between the lines were saying there are a few people who are involved in this case that don't have a sense of humor, because they referenced that this is a style of humor parody that some people don't have an appreciation for. So I think they are also looking at the overzealous nature of going after someone for posting. Mm-hmm. And the post, I get it. I've done work for Parma. I understand that there might be those who don't like that humor, but a criminal case, I mean, that's going a little bit far. I do want to point out one other thing that is in Larry's outline is, because it goes back to what we were talking about earlier, on page 11 of his, we talked about the policy itself and overbroad. I forgot about this, the Liverman versus City of Petersburg, Virginia. And those of us who went to school in Virginia, that's pronounced Virginia. Because I went to the Virginia Tech, by the way. I take a look at that on page 11 because there's an analysis of the language of the policy in Petersburg and the court's finding in that case. So there's another case there for you, and a lot of specificity in Larry's outline on that.
Larry, any additional follow-up on that from you?
No, I think we also cite a number of articles that you can go to that may give you some idea, particularly when Terry asked the void for vagueness question. But again, I think, you know, we started out and say one size does not fit all. And I would say to you, and this is where, depending on where your bread's buttered, you know, I looked at the Garcetti case, and that's where I told Jonathan it was a 5-4 decision, as was the Connick case was a 5-4 decision. And there were you know, obviously there were strong dissents and there was strong language in those dissents. But this is an evolving area. I think what we can leave with you is audit your social media policy at least yearly. have a little note when you did it, meet with your employees, get feedback from them. Has this been working? Is there anything unclear? Are there any amendments we need to do? I think the other thing is usually government legislative bodies adopt these policies. So whether it's your city council or your trustees or whoever it is, to formalize those. And I think that will give you a stronger leg that your intent was to comply with the law as to be overly broad or overreach.
So let me talk about one other thing, Terry. There's one other point here that I think is important. It's in both of our outlines, which is this. You may still discipline employees for misconduct, notwithstanding their public speech. And the courts are very clear on that. If they've done something that warrants discipline, this is the but-for or the retaliation claim, if it's separate and apart from the conduct on social media or public speech, for instance, lying, falsifying reports, and whatever you have a clear violation of. The fact that they've made public speech through whatever means does not insulate them from misconduct in the future. It'll be thrown out that this is you're doing that in retaliation. Well, the courts are very clear on this in discrimination law, in public speech law, that notwithstanding the protected category under Title VII or ADA or FMLA, if there's the basis for discipline, you may move forward, but be ready to be able to respond to the allegation that it's done in retaliation for speaking their mind.
Correct. Correct.
Good. We got a question from Chris. Chris, go ahead.
Sure. This is from a state commission, and the question surrounds much, if not all, of the Q&A is around Facebook messages. What guidance do you have for a state commission, primarily using Twitter and LinkedIn, to share messages about programming from our public education broadcasters? And what's our liability if an employee at a public broadcaster offers personal opinion via the channel?
Same, doesn't matter. I don't care what you call a platform. Same rules.
Okay.
You have to have a policy. You have to have a policy that says you can take it down if it meets these standards. And that's where you get back to, if you look at the Knight case, you look at the others back at that time, you have to have a clear policy. And I think if you go back to the Ohio Electronic Records Committee social media policy language shared through this, you're going to find the standards in there as well. But again, that's the policy about the whatever electronic source or media source you're using, it applies. I don't care if it's Twitter, whatever the newest one is tomorrow.
Let me ask a question. We've had some cases before our state personnel board involving public employees who might have been happy or unhappy with something, and then they post something on their Facebook that involves the Confederate flag. And obviously the Confederate flag is sensitive to some people. Where's the line on something like when they post something? And also we've had some cases where it's a difference if they're pictured on their Facebook wearing their, let's say, corrections department uniform, that's a little more over the line. But if they're not saying any connection to their public employment, where's the line on pictures they show or identification? And then also the magic thing of the Confederate flag. Is that a absolute no-no, maybe wrong if and if, or not wrong, or is it protected? Where there's a couple questions that we've had over time and before our board on that.
Larry, what do you think? Are you going to go?
I think, the Confederate flag alone in a background or a photograph versus a KKK hood is going to be different. I think the courts, and we've seen this in university areas where students have had the flag draped over. And you have those policies in universities and colleges are notorious of not wanting anyone to disagree on anything. But I think the flag alone is not going to be enough to probably sustain discipline, except if you have your house on fire, the mayor or whoever is going to fire them and they're going to get their job back, probably. Jonathan?
I don't see any difference, in my opinion, burning an American flag or showing the Confederate flag. It's a political expression. Now, Terry linked another set of facts in there, which is if he's wearing his corrections officer's uniform, now he's stepped over the line. That's clear. I mean, that's a. By the way, there was a Larry. I don't know if you caught this. The case that came out of Shawnee State University that the Sixth Circuit just ruled in the last couple of months, and I'll think of the name of it here in a second, where a professor's refusal to use a student's gender identification because of his position as religious position that he that was against his religion to do that. The case settled for $400.
Yep. So that was one of those classic situations of pronouns or whatever you want to call it. And this, I mean, the university area is really, we're going to go through a lot more changes in that segment because it's just so fragile. But I think as Jonathan said, if you're in your uniform, the ground rules change.
So Terry, overall,
Chris, got a question. Go ahead, Jonathan. Finish up, Jonathan.
It's people who don't agree with the policy statement being made. If it is that, if it's a policy issue. So for instance, being required to use gender identification of the individual's choice. They can speak out on that because that's a policy of the university. But they need to do so, and this is where I caution in writing your policies, making sure that people, don't say something stupid in there. You can go over the line if you identify yourself as the professor, as the police officer, as the corrections officer. But if you're speaking as a public citizen, I think you have every right to be critical of it. The same way that we've had critical race issues, we've had a number of things. And if you think about it, and this is my moment on the podium, which is we have come a long way in the last 60 years. I can't wait to see how far we go in the next 60 as well. I mean, it's just a tremendous number of things, and this freedom of speech issue is where we are today because of the proliferation of electronic platforms.
Chris has got a question, and
yeah, Roger wants to know what the limits of a social media investigation from an administrative perspective is, and is it limited to open source information, or could a subpoena for more detailed information be obtained?
Yes.
Yes.
Okay, great.
That's pretty succinct answers that way, and
the other
but I take it social media is a two-way street. You can express your opinion, but I take it the employers could also dig and look for stuff to potentially go after you. Am I right in that generalization?
Right.
Yep.
Terry, there's a line of cases right now, starting back with Quan versus San Diego, about the ability of a public employer to access the electronic devices. I mean, Quan is so old that it was the pagers, but today the issue is the cell phones. Who owns the cell phones? The Sanderson decision out of the Sixth Circuit Court of Appeals said, if the phone is surrendered, you can access it. But my advice to clients is, if you don't own the phone, get a subpoena.
Yep, that's exactly right.
If you don't own the laptop, get a subpoena.
Yep.
Don't mess with it.
I'm looking at the clock, and we're a little after 11:30, and obviously our two speakers have not only been excellent, but been very succinct and on point, and probably if we tallied it up, they probably agreed more than they disagreed, even though they sometimes come at things from an employer versus an employee route. But unless there's any other questions right now from Chris, wanted to kind of give an opportunity for, we'll let Larry go first if there's any kind of summary bottom line. If you were to say whether you're an employee, employer, union rep, whatever it is, local, county, state, university, et cetera? Are there 2 or 3 key bottom lines in summary to keep in mind? We'll let Larry go first.
Yeah, I think more than anything else, and I live in a world that easily the house can be on fire, but between employees and management, I would say that we're in this fight, this struggle together. So let's use our best resources, our best connections in trying to come up with something that works for the benefit of everyone, because unless you have an overzealous administration, and again, we see these from time to time, it's only going to hurt the taxpayers, the citizens, and the employee and management. We can't win without each other. I'll leave it at that.
Great summary, Jonathan.
I agree wholeheartedly with my learned colleague. The key thing for public employers is this. The issue about freedom of speech is on the front burner of plaintiffs' employment lawyers who bring lawsuits against entities. The Sanderson case, I think, is Anderson case is a perfect example of that. And so if you're going to take action, you need to have a clear, clean policy. And quite honestly, my advice to all our clients constantly is you should be reviewing all of your policies at least once a year and rotating them through and reviewing and going over those with your employees. It's kind of like oil changes in your car. I mean, if you don't change oil, it's not going to work. So to me, it's a constant, and it comes up in many different sectors. So it's not an all one policy fits all. There's a blending of the policies. There's coordination of the policies. And with the advent of computers and word search, they're a whole lot easier to write and draft and keep up to date. And so the other thing I want to say to everybody that's in the audience, thank you for your service to the public. That is greatly appreciated. My first job for 3 years was with the Department of Administrative Services, and I have the highest respect. I have family members in public service, some formerly in the military, and so to me, I want to say thank you, everybody out there who's serving the public.
Great, excellent summaries. And again, to reiterate that we're going to have this whole discussion archived so you can go back and look at it. And there's obviously a wide range of great materials provided both Larry and Jonathan. And in the future, please check back at our website, and we're going to have some upcoming programs on Civil Service Commission, and we also hope to return to an in-person program in later August. But this has been excellent. We appreciate all the responses, and we held up over 500 people even towards the end. So again, the super thanks is to our great speakers, because they were the stars and made the difference, and we appreciate their participation, as well as they noted correctly the excellent work by our public employees who are dealing under challenging circumstances, particularly in the last 2 years. So thank you, everybody, and to our staff here at SPBR and CERB, including Justin, who was doing the technical switches, and we'll get everything posted up. We thank everyone for your help and your participation today. Thanks again.
Thank you.
Thanks.